Hello everyone, I'm Barrister Garn from Siam Center Law Group. Today we're going to talk about a very important step in criminal proceedings in Thailand, filing a criminal complaint and the inquiry hearing on the merits of the charge. Many defendants and even some practitioners underestimate how decisive this stage can be. Once a criminal complaint is filed, the case does not automatically move to trial. The court must first examine whether the complaint has legal and factual grounds. This filter is intended to prevent malicious, frivolous, or baseless accusations from entering the criminal justice system, because once the case is accepted, the defendant will immediately face serious consequences such as having to appear before the court on every hearing, applying for bail, travel restrictions, or even administrative consequences in employment or civil status. Not all cases require this inquiry. When the public prosecutor files the case, it is generally presumed that the facts and evidence have already been reviewed at the investigative stage, so inquiry hearings are typically not required. However, the court retains discretion to order such inquiry if necessary. But when a private complainant files directly with the court must conduct an inquiry hearing to determine whether there is sufficient merit for acceptance. During this stage, the complainant must submit a complete complaint, identify witnesses and evidence, and produce witnesses for examination before the court. The defendant has the right to cross-examine, and although traditionally the defendant could not present witnesses at this stage, the 2019 amendment to Section 165/2 of the Criminal Procedure Code introduced significant protections. Defendants can now submit written factual and legal statements together with supporting evidence or precedents, request the court to summons defense witnesses or documentary evidence, and in serious cases such as capital offenses or where the defendant is under 18, request appointment of court-appointed counsel. The standard of proof at this stage does not require eliminating reasonable doubt. It is similar to a threshold of roughly 50 out of 100 if the court finds that the accusation appears sufficiently grounded. The case moves forward. If not, the court may rule that the case lacks merit and the complainant still retains the right to appeal. In practice, lawyers must strategize carefully. A written submission under Section 165/2 should ideally be filed well before the hearing so that the judge has time to review it. Parties should consider whether to produce evidence merely sufficient to pass the threshold or to present more extensive testimony for strategic advantage. The court gives greater credibility to direct testimony than to testimony via authorized representatives, and where the defendant requests a postponement due to scheduling conflicts with another hearing, the complainant should avoid objecting to prevent being ordered to present evidence before the defense is prepared to cross-examine. Understanding the real function of the inquiry hearing on the merits allows defendants to protect their rights and allows complainants to avoid procedural pitfalls. When handled properly, a case that lacks merit can be dismissed at this early stage. When handled poorly, a defendant may be forced into a long and unnecessary trial.